Hi, my name is Nur Atika binti Ahmad Hilmi, and the topic for our assignment that we received is how far Section 6 of Civil Law Act regarding the prohibition of English law in the Malaysian court has been affecting the transaction of jual janji. Before the coming of British into the Malaya land, the Malay people has been practicing jual janji transaction for many years, as in Ramah against Latun. Islamic law is not a foreign law. So back in the days, the Islamic law has been modified into the custom. And in the early days, this transaction has been formed orally, an oral agreement between the borrower and the lender without any documents or registration takes place. As we know, Malaysia used a torrent system that originated from Australia, and Section 6 of Civil Law Act prohibit the English law. So rise to issue whether the application of equity principle is allowed or not. But in this video, we will focus on it is allowed. Equitable is allowed on the jual janji transaction. In the leading case, Haji Abdul Rahman against Hassan, the security transaction of jual janji is not a mortgage, as the National Land Code did not recognize or silence, because the wording in the National Land Code used the word charge. The liberal interpretation of a jual janji transaction consists of equitable principle. This is because a collateral agreement to retransfer the land back to the borrower in nature consists of equitable security transaction. Thus, if Malaysian court really want to refer to the Section 6 which prohibit the English law together with the equity into the local, then it will lead injustice to the people, as jual janji transaction has been practiced for so many years, for 100 years before the coming of the British, before the reception of English law, whether statutory or judiciary. It is hard for them to not to exercise a transaction that includes riba. In the case of Wu Yok Wan against Lu Pek Chi, the judge stated that equitable interests in land are allowed.
Moving on to the next point, which is jual janji and Section 6 of the Civil Law Act 1956. Jual janji is a category of security transaction and codified as a type of personal law transaction that is frequently practiced amongst the Muslim Malay community. So this transaction is to avoid the payment of riba or interest that is prohibited by the Sharia. The transaction requires the transfer of land belonging to the lender for consideration of a loan granted by the lender with a condition or promise to retransfer land to borrower upon full and final settlement of loan within an agreed period of time. So, if the borrower fails to regain the land within an agreed situation, the transaction will be held as jual putus. This can be proved with the case of Tengku Zahara and Che Yusof. In this case, the judge said that the whole purpose of jual janji transaction is to allow a procedure for securing a loan without infringing the prohibition of usury, which is binding on the conscience of all good Muslims. Apart from that, jual janji is capable of registration. The process includes the execution of two sets of 14A, Form 14A, as prescribed following the statutory form in the National Land Code 1965 to be used to register a transfer of ownership. Case of Sembah Gavali anak perempuan Muru Gason and T. Seng Hock. In this case, the plaintiff and the defendant signed the Sale and Purchase Agreement (SPA) and Form 14A of the National Land Code for the sale of the land. For Section 6 of the Civil Law Act, only forbade the application in Malaysia of English land tenure and any rules of equity which allow the concept of equitable estates and rights involving the concept of the bare trust. However, it does not forbid the application of the general principle of English equity. So, the relation between jual janji and English law pertaining to mortgage is that being a disposition of property to another security for a debt is that the mortgagor has an equitable interest or estate in the property mortgage, that being his or her right to redeem the property even if the time specified in the contract has passed within that period. So nevertheless, there is no provision in the Malaysian National Land Code 1965 resembling the English equity of redemption. The application of equitable principle in jual janji can be seen in the case of Yaakob bin Labai Jusoh and Hamisah binti Sa'ad. So in this case, the appellant transferred his land to the respondent to secure the land of 2,000 ringgit. So they executed an agreement to resell the land at the same price within 3 years. So the appellant failed to repay the loan within an agreed duration, and the respondent refused to retransfer the property. The court held that the real intention of the parties was to create a mortgage to secure repayment of loan. So the collateral agreement is in the nature of an equitable security transaction wherein the right to redeem remains irrespective if the duration has expired. Besides, the recent development in Malaysia is that jual janji can be recognized as a customary security transaction pursuant to Section 4 Clause 2 of the National Land Code 1965 and also Section 206 Clause 3 of the National Land Code provides that the contractual operation of any transaction relating to alienated land or interest will not be affected. It preserves the contractual obligations or an in personam claim to strike a balance to the indefeasibility of title under the torrent system.
Moving on to the issue of recognizing jual janji in Malaysia, first we're going to discuss on how far Malaysia has maintained issue on jual janji. The Civil Law Act and the National Land Code is considered to be the most comprehensive and complete law that governs any land matters in Malaysia, and Section 6 explains about the prohibitions on the use of English law and equity in any land matters in Malaysia. Jual janji is the concept of Islamic custom where there should be no usuri or riba in any matter related to land. However, Section 6 are not able to fully prohibit the use of English law and equity in Malaysia. There are two views. The first views mention that the English law and equity law are not applicable at all in Malaysia land matters. This is because, referring to the case of UMBC and Pemungut Hasil Tanah, where the Privy Council believed that the National Land Code is a complete law governing any land matters in Malaysia. It was also made in view of the Haji Abdul Rahman's case, where the applications of equity law has caused great injustice and unfairness made by the court. Therefore, English law and equity could not be applicable to Malaysia land law because it holds a different concept from jual janji. The second view mentioned that the English law are applicable in land matters in Malaysia. In this matter, the court believed that Section 6 should be read together with Section 3 of the Civil Law Act. This is because Section 3 mentioned about in the absence of the written law in Malaysia, the English law or the equity law may be applicable to fill in the lacuna or the gap in the law. The other reason for English law to be applicable in Malaysia is because the court believed that National Land Code only regulates on rights and obligation, where it only regulates on matter after registration and not before the land is registered. Thus, the court viewed that the National Land Code is incomplete because it does not govern on matters before the land is registered. As far as jual janji is maintained in Malaysia, there are two views or two interpretations, which is strict interpretations and liberal interpretations. For strict interpretations, the essence of times are taken into consideration, where the failure of the borrower to repay the money within the time stipulated, he will not be entitled to reclaim his property. However, there is an exception to strict interpretations when the lender had agreed to make an extension of time, meaning that the essence of time will not be taken into consideration, as referred in the case of Ismail Haji Embong and Lau Kong Han. For liberal interpretation, the essence of time will not be taken into consideration, where the borrower does not have any time limit to pay his loan and he will be entitled to reclaim his property anytime. The second part is the receptions of equity in registered land. Brief explanations about jual janji in registered land. The borrower needs to fill two sets of Form 14A. That is, the first set enables the borrower to be the transferor and transfer his land to the lender, while the second set of the Form 14A enable the lender to exercise his right over the land for the period where the loan or the agreement is still valid. Once the agreement was fulfilled, the lender needs to give back the land or the property to the borrower, and he will not have the right over the land anymore. English law and equity that are applied in matter relating to registered land is equitable ownership. It is similar to the concept of jual janji, where referring to the case of Munah and Fatima, when the borrower failed to pay the loan, the lender will have full right over the land. Equitable ownership shows that the person or the lender will have full right over the land once there was agreement made between the borrower and the lender. Therefore, when the agreement was made, the lender will be able to exercise his right over the land. However, when the borrower failed to pay his loan, the lender will have full rights over the land. The concept of jual janji and equitable ownership is similar. Therefore, it is unreasonable for English law and equity to be inapplicable in this situation. The third part is the receptions of equity in unregistered land. In matter related to unregistered land, Section 5 of the National Land Code does not specifically explain about the essential of lease. However, English law touches on the matters where it explains that under the element of lease, the person will have exclusive possessions over the land. As explained in the judgment of Siu Sun Wah's case that mentioned about uncertainty and vagueness or clarity regarding the essential of lease. First, mortgage is used when the lender will be given the right to a registered land by the borrower and will have exclusive right to the land until the loan is fully paid by the borrower. Lease is a form of rental where the lender has the right to live there as long as they had paid their rent, and it will not give the lender full ownership as to request the occupier to vacate the land. Therefore, the usage of lease in Malaysia relies on English law and equity principles, as there is an absence of clarity in the National Land Code regarding lease. However, there is an application of English law and equity in land matters in Malaysia. Thus, Section 6 are not able to fully prohibit the use of English law and equity in Malaysia land law.